Okay, so this is a continuation of where I left off regarding um, the death penalty and the moral and ethical issues that come from the death penalty. There's a host of them, of course, but a few of them that we want to touch on. Um, as I was mentioned about Illinois Governor Ryan, his decision to simply commute the death sentences of 160 people 2 days before he left office begs the question whether or not it's morally and ethically permissible to have the death penalty when you can do such a thing, and at the same time to have the ability to reverse the imposition of a death penalty based on one individual's thought process. His rationale being that he felt as though that there were a number of issues from a prosecution perspective, as well as with the advent of some technology that strongly suggested that those sitting on death row shouldn't be on death row. So 2 days before he left office, he commuted 160 sentences. Those were the death sentences. They were not released from custody. Their death sentence, however, was commuted. We should talk a little bit about the actual imposition of the death sentence and how that goes about and whether or not that withstands scrutiny under the Constitution. In the case of Baze versus Reese, B-A-Z-E versus Reese, R-E-E-S, a 2008 case out of the state of Kentucky, the Supreme Court ruled that the use of lethal injection did not involve an unnecessary risk of inflicting pain during execution and was upheld as not an inappropriate means for carrying out a death sentence. Glossop versus Gross, a 2015 case from the state of Oklahoma, again, Kentucky, Oklahoma, states that have permitted the death penalty. In that particular situation, the Supreme Court held in a 5-4 decision that using a 3-drug protocol, that is, drugs at first would cause somebody to fall unconscious, and then ultimately the follow-up drugs that would cause the heart to stop beating, was not an inappropriate means for the execution of a death penalty. There have been, over the course of the last number of years, a number of botched executions. There was a case of Dennis McGuire in January 2014, state of Ohio, where it took 20 minutes for Mr. McGuire to pass away as he was gasping for air for 10 to 13 minutes, even though he was given this 3-drug cocktail that would cause his death. Clayton Lockett in April of 2014 out of Oklahoma. It was a 43-minute process, and he was convulsing and spoke during the process, attempted to rise from the execution table 14 minutes into it, despite having been declared to be unconscious. These types of instances call into question as to whether or not the use of these drugs to impose the death penalty are cruel and unusual means by which the death penalty occurs. As it stands right now, the use of those types of chemicals in a drug manner is not inappropriate. Those states who want to use it, some states consider other means, the electric chair. Some states are even thinking about the firing squad and returning to that method. As it stands right now, most of them, however, use the chemical 3-drug cocktail chemical mechanism to cause the death. Sometimes we have, along the lines of these ethical and moral issues, the federal-state overlap concerns. What I mean by that is, what if a crime occurs within a state where under state law it is not permitted to actually impose the death penalty, but federal law does, and whether or not that creates a problem? Michigan has seen an example of that. The case of Marvin Gabrion, G-A-B-R-I-O-N. Mr. Gabrion was charged with and ultimately convicted of the kidnap and murder of a woman by the name of Rachel Timmerman back in 1979. Ms. Timmerman was supposed to testify against Mr. Gabriel for him raping her, and she was killed 2 days prior to when he was supposed to stand trial for her rape. Her body was duct taped and chained to cinder blocks found in a lake, and ultimately that was found on federal property. During the autopsy, the medical examiner said she had died from drowning, and the defense argued that she was killed somewhere other than on federal property. Ultimately, the court concluded that her death likely occurred on federal property. What's meaningful about this is that if it occurred on federal property, then it may be charged as a federal crime. If it did not occur on federal property, then Mr. Gabriel could not be charged federally for the crimes. As a result, because he was charged federally, and since the federal government has the ability to pursue the death penalty, ultimately his conviction led to a sentence causing him to die. He would be the first person sentenced to death within the state of Michigan in nearly 80 years, or approximately 80 years. He's currently on death row in federal prison for this crime. I bring this up because it was just as a result of where her body was found and a determination that it likely, the incident likely occurred on federal property, that permitted the federal government from pursuing the death penalty. Again, had it not occurred on federal property, then we're talking about a state crime where the death penalty is not an issue. This dovetails into the concept of what about us as a state that is in Michigan? We are, as a state, the first English-speaking government in the world to outlaw executions. We have been the longest state to have it abolished. Our legislature made that decision back in 1847, so it has been a good 170 years or so that we have not had by law, not have the ability under state crime to impose the death penalty. Why is this? Well, there's a lot of reasons why, but many of the reasons that we have had it since 1847 stem from a hanging that occurred in 1830. Stephen Simmons was sentenced to die by hanging. Whether it was the distaste for the spectacle, his repentance, and as well as some other graphic executions a few years later, that caused the state legislature shortly thereafter to pass a law that says that execution would not be a permitted sentence no matter what the crime. There have been efforts along the way to try to change this since 1847. There have been a number of various legislative bodies that have considered having an option as the death penalty for the state of Michigan, but it has not occurred. So we remain the state that has lived the longest of having it abolished. Certainly other types of sentences have to be looked at in terms of cruel and unusual punishment. I want to talk about one of them in particular. That is the 3 strikes you're out laws from the state of California. A number of years ago, as a result of what has become somewhat of a popular topic here. I should say popular. I mean, the name comes out. Her name was Polly Klaas. Polly Klaas was murdered by someone who had been released on parole. And because of that situation, the state of California, as well as a number of other crimes that were serious and violent crimes, the state of California decided to pass a piece of legislation that made it a mandatory 25-year minimum to life imprisonment sentence if you were convicted of your 3rd felony, commonly referred to as the 3 strikes you're outlaw. So what California wanted to do on the heels of the Polly Klaas situation was to make sure that people who have been convicted of felonies, that they spend an incredibly long period of time in prison. There were 2 cases that made their way through the California courts, ultimately to the Supreme Court, them by the name of Ewing and another by the name of Andrade. These 2 individuals were convicted of their 3rd felonies and were given 25-year minimum prison sentence. Mr. Ewing had stolen a set of golf clubs. It happened to be his 3rd felony, and when he was sentenced after convicted, he was given the 25-year prison sentence. Mr. Andrade had stolen some videos on some separate occasions, and he received 2 consecutive 25-year to life terms as a result of stealing some videos. Those cases, as I mentioned, went up to the United States Supreme Court so that they could determine whether or not the imposition of that harsh of a penalty, a 25-year minimum sentence, was cruel and unusual. And in that situation, they were joined as a case, the Supreme Court ruled in a 5-4 decision back in March of 2003 that it was not cruel and unusual to impose a 25-year minimum prison sentence for those nonviolent theft offenses. In other words, the Supreme Court said that if the state of California wants to lock these people up for long periods of time, and similar people, it's certainly within their purview, not a violation of the Eighth Amendment. I also want to spend a minute here talking about whether or not the Eighth Amendment and punishment under the Eighth Amendment violations occur when somebody's sentence is being imposed. That is, while they are in the custody, that are not death penalty cases. Jailhouse situations, if you will. The Supreme Court has determined that the Eighth Amendment also guarantees inmates the right to be free from cruel and inhumane treatment. Prisons are required to refrain from unnecessary and sadistic applications of force that serve no penological purpose. In the case of Hudson versus McMillan, which is at page 484 of your book, corrections officials gratuitously and repeatedly punched an inmate on his way to the lockdown. He complained, filed a suit against them, claiming an Eighth Amendment violation, that is, cruel and unusual, the execution of the punishment, and the court ruled that it was an Eighth Amendment violation, in that the gratuitous and repeated punching of him served no penological purpose, and it was a sadistic application of force that had no appropriate basis and therefore an Eighth Amendment violation. Can prison officials, jail guards use deadly force? They can. They can if they have a subjective good faith belief it is necessary under the circumstances. Whitney versus Albers, a page 484 case. What happened in that case, there was a cell block disturbance. Some officials shot an inmate, and the court said that this was not, that is, the appellate court said that this was not an Eighth Amendment violation because there existed a good faith belief that it was necessary to restore order in the jail. So you can't do unnecessary, sadistic, no penological purpose application of force. You can use deadly force if it's warranted under the circumstances, if you have a good faith belief it is necessary. What about providing an inmate's needs? The government does, under the Eighth Amendment, have an affirmative duty to provide basic human needs when the individual is deprived of the ability to obtain them on their own. So when you are in custody and the government controls what it is that you have as a place to stay, your medical care, your food, things of that nature, the government has an affirmative duty to provide your basic human needs. And that really comes down to declaring that you are entitled to minimally decent conditions of habitation, that you are safe from attack, and that you get care for serious medical needs. Now, does that mean that everybody who's incarcerated gets treated for all medical needs? No, you get care for serious medical needs. If you have cancer, then the government has an obligation to provide you treatment for that serious medical need. If you have a hangnail, that's not a serious medical need where you are guaranteed treatment. So, because you can't get it on your own, because of your incarceration, the government, under the Eighth Amendment, has an obligation to provide care for serious medical need. Safety from attack. Does that mean that you're not going to get attacked at the jail or prison? That doesn't mean that. In order to prevail against the government, the defendant or the prisoner must show that the basic need was not being met and that the government acted with deliberate indifference to that fact. So when it comes to safety, if the government knows that you are likely to be attacked, and if they act with deliberate indifference to the fact that you are going to be attacked, then that may very well rise to an Eighth Amendment violation. So the government has to know that your need was not being met, whether it would be safety from attack or decent conditions of habitation or the serious medical needs. They need to know that whatever need that you have was not being met, and their actions were deliberately indifferent to that fact. When you have that, then the government's obligation to provide you these types of things while you're in custody has been shown to be an Eighth Amendment violation. The Eighth Amendment, we can talk at great length about it. I'm going to leave it to those concepts that we just talked about in this section, and for the 20 minutes or so in the previous one, all this can be found in the book in those pages that I mentioned. That'll be the end of distance learning number 7.